Hello and welcome everyone. My name is Sally Pinto and I'm from the Yonkers Newark Neighborhood Naturally Occurring Retirement Community. We launched back in January of 2020 and we're here to serve seniors 60 plus in Northeast Yonkers. We have lots of fun programs and activities, and we also have a lot of resources for you as well. Our programs include meditation chair yoga, body mind fitness, bingo, and any other programs that you might be interested, like arts and gardening. We have our resource specialist, Alexis Smith, who can help you with finding services and activities out there for you, as well as our nurse, Barbara Simone, who can help answer your health-related questions. We're here for you, we're here for our community, and we look forward to seeing you in our programs. Enjoy.
Hello, everybody. I'm Alexis Smith, the resource specialist with the Yonkers Newark. I'm here to help with application assistance, referrals for home-delivered meals, and transportation services will be coming soon. We also offer Zoom activities and Zoom programs. And if you have any other questions or concerns, I'm here to help. Thank you so much and enjoy the program.
Welcome. I'm Barbara Simone, registered nurse. I recently retired from Westchester County's Health Department as a public health nurse. I am now here to try to assist you with any medical or preventive care issues. Enjoy this program, and I'm looking forward to working with you.
Sally, thank you for having me back, and thank you to the Yonkers Newark for having me back. But really, more importantly, thank you to the Yonkers Newark and WJCS and the Yonkers Office for the Aging for really being able to make education and information so accessible to seniors. So as Sally said, she can't pronounce the name of my firm. It's Ania, Scanlon, and Sirignano. We're located in White Plains. I'm a partner here. Again, my name's Sara Meyers. And when we spoke last time, we talked about Medicaid, the importance of Medicaid planning, estate planning, and upcoming changes with the Medicaid rules. And during that presentation, we had a lot of questions concerning estate planning, probate, surrogates court, and what happens when someone passes. So first, when we're talking about what happens when someone passes, we're not going to be discussing anything theoretical, metaphysical, and the like. We're really going to be talking about what happens when someone dies without a last will and testament, and then legally what happens. We are a small group this afternoon, so please feel free to either put a question in the chat, and I'll try to look down periodically to see if questions are there, or if there's a natural break, feel free to unmute yourself and ask the question. So what happens legally, again, not theoretically, philosophically, religiously, when someone dies without a will? What happens is this, and I think we discussed bringing this topic to the fore here because there was a common misconception that when someone dies without a will, the government takes their money or the government takes control. So I wanted to explain that that's incorrect. It's a bad misconception, and that if you don't die without a will, it's okay. There's a statute under with the laws that says what happens when you die without a will. So what happens when you pass without a will? First, the government doesn't take your money. Second, the courts look to a family tree. So if I pass away and I don't have a will, and as an aside, I do have a will, and I do recommend that everybody over the age of 18 or everybody who's older, who's working, married, widowed, divorced, not married, have a will, as well as those advanced directives, power of attorney, and healthcare proxy, and we'll discuss that in a little bit. So if I pass away without a will, the courts look to see who are what are called my distributees, who are my bloodline, and who I am if I am married. So if I die without a will, I'm married and I have children. The courts say my husband gets the first $50,000 of my estate, of what's in my name alone, plus 50% of the remainder. And the other 50% goes to my children. I have 3 daughters. My 3 daughters would divide up their 50% equally. If I should pass without a spouse and have children, my estate, my funds would go to my children. If I should pass without a spouse and without children, the court looks to see if I have parents, a parent or parents surviving. If I do, my estate, the funds get paid to them. If my parents are not surviving, but I have surviving siblings, my estate gets paid to my surviving siblings. If they are not surviving, to their children. So there's a complex family tree of who are what are called the distributees, who are to receive the funds if I pass without a will. And that's an excellent question, Sally. What happens if the children are minors? So if I pass, and when I pass, everyone's going to pass, at some point, but if I pass without a will and I have children and a child or children of mine are minors, not only that the funds going to that minor child. So let's say I have $400,000. Let's say my minor child is to inherit $50,000. Because I have made no provision, I have no will, the funds are held in an account by that child's guardian. Now, what'll happen is a proceeding called an Article 17 proceeding under the SCPLR, which is the Surrogates Court's laws and practice or rules, basically says the surviving parent would have to bring a proceeding to be appointed that minor child's guardian of the property. And then the funds that that child gets from the estate are held in an account titled with that guardian until the child turns the age of 18. If there's no surviving parent, a grandparent or an aunt, uncle, a blood relative would have to petition to be appointed that minor child's Article 17 guardian to hold those funds until that child turns the age of 18. So Sally, back to your point, it's so important for new parents or for parents with minor children to do their estate planning. So for example, as I said, I do have a will. In my will, it says if my husband is surviving, he is our children's guardian. If he is not surviving, we have one of mine and my husband's siblings being any minor child's guardian, because we wanted to choose who should be that child's, the minor child's guardian if, God forbid, something happened to both my husband and I. When it's up to the court, it's the person, either the grandparents or the surviving, aunt, uncle, the siblings, who then have to determine and who is going to petition to be that minor child's guardian. So again, it's so important to have that will, because then you get to make the decision first who would be a minor child's guardian, but also at what age should your child or children inherit. So for example, if I die without a will, and let's say my estate is significant, or even if it's not, my children, no matter the age, or we'll call it 18 or up if they're under 18 though, until they're 18, would inherit their share of the estate outright. If I have a will, I'll answer that question in a second, Sally. If I have a will, it says, my children get X amount, whatever my children get, it stays in trust until age 25, 30, 35 with a trustee. So there's more control. So we don't have 18-year-olds inheriting funds. Sally posed a question here. Is it true that minors go to the state before going to a relative? Sally, thank you for answering that. And again, we'll clear up another common misconception. The same way it's not true that if you die without a will, the government, the state gets those monies. If you die without a will and you have a minor child, and the minor child's other parent is not surviving either, a family member can petition the court to be appointed that child's guardian of the person and or property. Especially when there's a family member, the state does not say, hey, we're going to yank this kid and put him or her in foster care. A family member would be asked to petition the court to become that child's guardian. Again, that child doesn't go to the state and isn't pulled out and going into foster care or other care. Really the family, please God, there is family to step up to petition the court to become that minor child's guardian. And stepping back for a second, what assets pass through an individual's estate upon passing? And I know last year when we talked about Medicaid, we hit on this as well, but I think it's so important for people to understand. If I have a bank account joint with my spouse, my child, or anybody else. So it's joint, it's Sarah and Sally Pinto are named on a bank account. If I should die first, that bank account goes to Sally by what's called operation of law. There's a joint owner to it, so that account would not be part of my estate, either for estate administration or probate when there's a will, because that account has a joint owner. So again, if Sally and I have an account that's titled Sarah and Sally, upon my passing, that account passes by operation of law to Sally. If I have a bank account that's in my name, Sara Meyers, in trust for or payable on death or transfer on death to Sally, and Sally, there's no implied contract here, just using you as an example. Upon my passing, that account, again, would pass by operation of law to Sally and would not be part of my estate for distribution under my will or to my distributees. It falls outside of the estate because there's that named beneficiary. The same if I have a retirement account or life insurance policy or brokerage account or an annuity, any asset that's either titled joint with someone or a named beneficiary passes outside of the estate and goes to that named beneficiary. If I have a house and Sally and I own the house and it's titled joint with right of survivorship, if I should pass, again, that house goes to Sally by operation of law automatically. Again, it's not part of my probate estate. If the house were in my name alone, it would be part of my estate assets and distributed either pursuant to my will if I had a will, or pursuant to the estate administration and either to the spouse or to the children. So the only assets that are part of my estate for either probate, which is when I have a will, or an estate administration when I don't have a will, are those assets that are in my name alone at the time of my passing and have no named beneficiary, payable on death, transfer on death designation. So when someone will say to me, hey, Sarah, I don't need a will, I ask them, I say, well, why not? And I think everybody should have a will, and we'll discuss the importance of a will in a couple of minutes. But yes, if a person's, all of his or her assets are titled either jointly with another or payable on death, transfer on death of another, that is away or in a trust to avoid probate. But as we all know, there's always that account that we forget about that might be in my name alone, thus necessitating upon my passing, my will being admitted to probate or having to do an estate administration. So again, let's reiterate, if I die without a will, the government doesn't get, or the state doesn't get those funds. It passes to my estate, and we do what's called that estate administration here in Westchester County with the Surrogates Court of Westchester County. An application is filed with the court seeking to do an estate administration and appointing an administrator of the estate. When someone dies with a will, a probate application or a probate petition is filed with the court, and the person who's the nominated executor under my will would be the one to file that petition. So what's the downside of not having a will? And let's go through a couple of the downside. First, in my will, I can choose who I want to be the executor of the estate. With an estate administration, I, the decedent, don't have that choice. The courts look first to see if I have a surviving spouse. If not, the courts look to see if I have surviving child or children. And then those children would be the ones who have the ability to petition the court to be the administrator. But let's say I don't have a good relationship with one of my children, or let's say I don't trust that child, or that child has an opioid addiction or some mental health issues. I wouldn't want that child being the administrator, but I don't have control of that because I will be deceased and I haven't done a will naming who I would like to be the executor who would be in charge of my estate upon passing. And as we alluded to earlier as well, with an estate administration, we follow the statute as to who are the distributees who would inherit under my estate. With a will, I get to choose who my beneficiaries are. Let's say I have a child who stops speaking to me. I might not want to leave him or her anything under the will. Let's say one child is much more successful financially than another child, I might want to give one child, leave one child a little more than the other, because I think that child might need more help later on. And also, what about grandchildren, right? Or a minor child? Maybe perhaps I want something being left in the trust created under the will, so they can't get everything outright at 18, but perhaps at 25, 30, 35, depending on how much is in my estate, because we might not want an 18-year-old inheriting a couple of $100,000, right? That could be a lot of money all at once. And again, in trust, it protects those monies and helps, keeps them, from not inheriting all at once and, buying a fancy car or going gambling and then not have anything left for that child. Also, God forbid, or if there's a child with special needs, and that special needs child might be receiving, Medicaid or SSI or disability benefits, we would not want that disabled child inheriting outright, because that inheritance may affect that disabled child's receipt of public benefits, of Medicaid, of SSI, Social Security, disability, or other disability benefits. So again, we'd want to create or have a will, and in that will perhaps have something called a special needs trust to go to that special needs child in order to protect that child's benefits, so that child doesn't lose benefits upon receiving an inheritance. Any questions so far? You guys have been very quiet.
We do have one question.
Yeah.
Can you talk about the advantage of trusts, revocable and irrevocable?
Sure. So we're going to put that in the context, a trust in context of an estate. As we were talking about earlier, the only assets that would pass through my estate, either via that intestacy and the estate administration, if I don't have a will, or my probate estate, if I do have a will, are those assets that have a named beneficiary or are titled jointly, payable on death, transfer on death, or joint with someone else. I also can, if I've done my estate planning, I might have created a revocable trust, an irrevocable trust, or Medicaid asset protection trust, or something known as a special needs or supplemental needs trust. A revocable trust is a type of trust that we create during lifetime, and any asset that's titled to that trust upon my passing would not pass through my probate estate or an estate administration, but would pass through my trust. So a trust is as good as the piece of paper that I have in front of me. When I have a trust, what's important to do is make sure your assets are retitled to that trust. So if I create the Sara Meyers Revocable Living Trust, I'm the creator or the grantor, and me, Sara Meyers, I can also be the trustee of that trust. If I have a bank account, and I'm just because it's right around the corner from my office at Chase Bank, though I'm not showing any preference for one bank or another, just using that as an example. If I have a bank account at Chase Bank, and that account is in the name of Sara Meyers, that account is not titled to my trust. In order for that account to be titled to my trust, I'd have to have the trust, the Sara Meyers Revocable Trust, created. I would then have to go to the bank or fill out the bank forms and retitle the name of the trust to the Sara Meyers Revocable Trust. Once the account is titled to the Sara Meyers Revocable Trust, that trust owns the account. I'm both what's called the creator as well as the trustee, and I manage that account instead of me personally, me as the trustee of that trust. The benefit of a revocable trust is upon my passing, there should be in the trust named a successor trustee. And he or she, let's say it's Sally is the successor trustee, she would take that account, pay any of my debts upon my passing, and then distribute the account, the assets titled to the trust, to the beneficiaries named in my trust. So we're avoiding probate, avoiding having to go to surrogate's court because the assets are titled to the revocable trust. So revocable trusts are very good when someone wants privacy and to avoid probate, to not have to pay an attorney to do a probate petition or an administration petition, as we said, when there's no will. There's no Medicaid asset planning or protection planning with a revocable trust, because the assets titled to that revocable trust are still mine. I'm still the owner of them. And therefore those are counted if I'm applying for Medicaid as my assets and towards the Medicaid asset limit, which for this year is $15,900 in non-retirement monies. Then there's also an irrevocable trust, also known as a Medicaid Asset Protection Trust. I would be the grantor of that trust, so it would be the Sara Meyers Irrevocable Trust. I, because it's an irrevocable trust, cannot be the trustee, so Sally can be the trustee, and I'd appoint Sally to be the trustee. Any asset that I title to my irrevocable trust, Sally would be the trustee, because she would handle the day-to-day, or if bills needed to be paid pursuant to the trust and whatnot, she would be responsible. But again, and I can be entitled to income, but the assets in the irrevocable trust, I can't get back. And those count if once I've transferred the assets into the trust, I need to wait that 5 years, because transfers into the irrevocable trust or the Medicaid Asset Protection Trust are considered gifts. And as we've discussed prior, there's that 5-year look back for Medicaid to see if any transfers of assets have been done when a person is applying for nursing home care. So if I created the trust, today is February of 2021, and I funded the trust in February of 2021, it's that Medicaid Irrevocable Asset Protection Trust, I won't be eligible for Medicaid to pay for my nursing home care until March of 2026. That's that 5-year look back. So Medicaid planning is very important, and it's important to do it sooner rather than later before the need for nursing home care would arise. I recall when we spoke last, we talked about New York State was imposing a 2.5-year look back for home care Medicaid, where traditionally there had not been a look back period for home care. I can create my irrevocable trust this month, February of 2021, fund it this month, be at the Medicaid asset limit by March 1st, and be eligible for Medicaid to pay for my home care, because again, there was no look back for Medicaid home care services. In the 2020 state budget, the New York State imposed a 2.5-year look back for home care Medicaid for transfer, for which was going to go into effect first in October. Then it was pushed to January. Then it was pushed to April of this year. Then it was pushed to July of this year of 2021. And we actually just got word yesterday that at this point in time, there will be it's pushed, the date for a transfer penalty for Medicaid home care has been pushed off indefinitely. So as of now, there again will not be a transfer penalty for home care Medicaid. So this was great news that we received yesterday, that there won't be that imposition of a transfer penalty for home care Medicaid, as we learned last year there was going to be. So again, as of now, the imposition of a look back period for home care Medicaid, which was supposed to start in July of 2021, has been pushed back indefinitely. Sally, did that answer the question regarding the irrevocable Medicaid trust and the revocable trust?
Yes, and they have a follow-up, plus we have another question.
Yeah.
The follow-up to that was, can you change the trustee on an irrevocable trust?
That's an excellent question. As long as the irrevocable trust has a provision called a power of appointment, and I'll tell you that our trusts, our irrevocable trusts do, you can change the trustee. You're allowed to change a trustee, and as long as it's not yourself, as long as it's still, again, not yourself, and you're also allowed to change the beneficiaries as well. So again, as long as an irrevocable trust has what's called a power of appointment provision, you as the grantor, as the creator, can change the trustee and also can change a beneficiary. Next question, Sally.
Okay. Can someone named as a beneficiary in a will also be named as the executor?
Yes.
Okay.
That was easy. So yes, mom has done a will. Let's say I'll just use me again. I've created the Sara Meyers last will and testament. My will has everything going to my spouse, Kenny. God forbid, if he predeceases, it goes to my 3 kids. I appoint my husband as the executor, my oldest daughter as the successor executor. he can act as my husband, if I pass before him, he can be the executor and the beneficiary. If he predeceases me, my oldest daughter, though I'd probably make my youngest, if she were older, the executor. Don't tell my oldest daughter that. The executor can also be a beneficiary.
If you have an irrevocable trust, how do you manage your accounts on banking and stock management?
That's another excellent question. And I appreciate the questions because I find it a much more robust discussion because it's good for me to tell you what the rules are, but I want to make sure you can all apply them to your day-to-day. So I have the Sara Meyers Irrevocable Trust. I am the grantor, and Sally, I'll put you in this position again. Sally is the trustee. With an irrevocable trust, I have lost control and I give that control to Sally. If there's a brokerage account titled to the trust, I can have the provision that the trustee can pay me at her discretion income. Other than that, but let's say I still want to be hands-on in the management and the buying of selling of the stocks or securities or the mutual funds and sort of being able to speak to my financial advisor regarding the brokerage account. Sally is the trustee, would basically give the advisor the permission to speak to me regarding the brokerage account. But remember, assets that are in the irrevocable trust, you're seeking to protect them from the cost of long-term care. So again, you want to be able to keep the funds in that trust intact as much as possible. When a trust, the irrevocable trust, owns the house, it's still me who's living in the house who's responsible for the property taxes on the house and the upkeep and maintenance. The reason why with the house, if it's in the irrevocable trust, I as the grantor remain responsible for the expenses, is that way I get to keep any STAR veterans or enhanced STAR exemptions because I'm living there. We give me what's called the life estate so I don't lose those property tax exemptions. Also then upon my passing, either with the brokerage account or the house that's in the trust, the kids or the beneficiaries inherit at what's called the date of death value. So we know a lot of people who bought houses in Westchester in the 60s and 70s, in Yonkers and other parts of the county. You could have bought your house in Yonkers in 1970 for $15,000, right? That same house that you bought in 1970 for $15,000 might be worth $600,000 or $650,000 now, if not more. When my kids inherit it, either under the will or in an administration or through a trust, they inherit it at what's called the date of death value. Not at the value that I purchased it, that $15,000, but at the date of death value of that $650,000. So when they inherit it and then they go to sell it, they, in terms of any what's called capital gains, and we're getting a little complex now, would start at the date of death value. So it's a big benefit, especially if a brokerage account has grown a lot over time or the house has increased in value over time, to not transfer anything outright to the kids, but let them inherit it either through the estate or through the trust to get the tax benefits of doing such. Sally, did that answer the question? I know I got off a little bit on a tangent there. My apologies.
I believe it did. If it didn't, they'll let us know. The next question, if I am single, no children, and a renter in my early 40s, is it a good idea to just get my account set as POD until I get to making a will?
Yeah, so that's an excellent question. First things, I think for anybody, because the person who asked you the question didn't ask about advanced directives being the power of attorney or healthcare proxy, and we'll touch on that in a second. Yes, because if you are single, not married, and no kids, and you pass without a will, as we talked about earlier with the rules of intestacy, the courts would look to see who your closest blood relatives for those assets for your monies to pass. So before, as a stopgap measure, before you create a will, yes, you might want to take your accounts and put named beneficiaries on them so that you know that you've designated who the beneficiaries should be. However, please recall, if at a later date, after you've added beneficiary designations onto those accounts, and you do a will, that you want the assets to go elsewhere, you'd have to remove the beneficiary designations because, as we said earlier, accounts that have a beneficiary designation don't pass through your will. They pass to the person to whom has been designated on that payable on death, transfer on death. Well, I do a lot of speaking on estate planning and the estate administration. And in terms of estate planning, and going back to the woman who asked that question, will or no will, if you'd ask me what are the most important estate planning documents, I'll tell you a power of attorney and a healthcare proxy. The reason being is when someone turns 18, their parents, though we're still their parents and still more likely than not supporting them, are no longer have the legal authority to make medical or financial decisions. So my kids' friends and people in my office always make fun of me. I have 3 daughters, 2 of whom are now over the age of 18. When each of my kids turns 18, the day they turn 18, they come into the office and they sign a power of attorney and a healthcare proxy. The power of attorney says if they are unable to do so, who they're appointing to make financial decisions for them. And a healthcare proxy, if they're unable to make medical decisions, who's to make medical decisions for them. I also have them sign a HIPAA form, and that's a release where they authorize me and my husband, their dad, to be able to access their medical records. Why is this so important? Because when someone's over the age of 18, or if your child is over the age of 18, you can't just call the pediatrician anymore and ask questions, right? The pediatrician talks to your child. If there's God forbid, they need to have surgery and you need to access their medical records, you can't do that without a HIPAA because they're over the age of 18. You legally no longer have access. So I do think it's incredibly important for anyone over the age of 18 to make sure they sign a power of attorney, a healthcare proxy, and that HIPAA. The power of attorney to make financial decisions, the healthcare proxy to make medical decisions, and the HIPAA in order to be able to access medical records. Periodically, I do get a question about what happens if I'm not married, have no kids, I don't want my siblings making these decisions, who can I appoint? There are some nonprofits that will step in to make the medical or financial decisions if you appoint them. A lot of times people will appoint their accountant to be able to be the one to make financial decisions. But it is important, especially if you don't have close relatives, to really have that healthcare proxy and the power of attorney to designate whom you wish to make decisions when you're unable to do so. Sally, anything else?
Yeah, we have a few questions.
If you have 3 children over 19, who should have the power of attorney? Okay, in terms of, so the question is, if you have 3 children over 19, who should have the power of attorney? So first, the legal age in New York is 18. So I'm not sure if the question is, who do I designate as a not 19 or 18-year-old, or who should the 18-year-old designate? So who do I think the 18-year-old should designate? My children, and I know this is being recorded, I basically, because I drafted the documents, I made myself the healthcare proxy with my husband, their dad, the alternate. And on the power of attorney, I did the same because I drafted it. When I do a lot of estate planning for my peers, the 30, 40, 50-year-olds, when they do have more than 40, 50-year-olds, when they do have children 18 or up, I always ask if they want me to do a power of attorney, healthcare proxy, and HIPAA for the children. And I do ask the kids which parent they want to make the medical decisions and financial decisions first. Because again, it's good to have their input. If the question is, if I'm doing a power of attorney and healthcare proxy and I have children over the age of 18, who am I choosing? I think that's an excellent question. I come across that a lot with my clients, right? They have 3 children and they don't want to insult anybody. Who should you choose as the agents to make medical decisions and financial decisions? If not, if you have a spouse, after the spouse, or instead of the spouse, or if no spouse and have those kids. And I say it's a very personal decision. A lot of times I'll have a client who says, I love my daughter, but her husband is domineering, and I know any decision I want her to make, he's going to make in her stead. So it is important to know your children as well as their spouses, if they have spouses, in terms of who you are going to choose to make those decisions. And it is interesting, and it's completely unscientific, but my clients in their late 70s, 80s, and older it's funny because I've noticed that they automatically choose a son to make financial decisions and a daughter to make medical decisions. Even if the daughter is in finance and the son is a doctor, they seem to put these certain roles with kids. But it's really important to know who your children are and who's able to make decisions in a crisis. For example, in a healthcare, if a healthcare proxy needs to act and it's a crisis situation, it's really important to be aware of your children. And we all know our children and their limitations, or friends and their limitations, and who would work best in what situation. And I wouldn't be worried about, insulting any of the kids for not choosing them. But I think COVID has really brought, and we always have to find I try to find silver linings in things. I think one of the silver linings of COVID and this pandemic is really bringing estate planning to the fore. It's not as much of a taboo subject, and really family members discussing in terms of the importance of estate planning, the importance of a power of attorney, a healthcare proxy, a living will, and what a person's end of life wishes are. So I think COVID has been a great opportunity to destigmatize estate planning and the importance of it, and for parents and children alike to really be discussing these issues with family members.
Okay, so we have another one before. Do I need to update my POA to the new one issued by New York State, or is the old one still valid?
Okay, so the power of attorney form and the general obligations law, which was where the power of attorney is found, went through a major revision back in 2009 and again then in 2010. And there's going to be a new power of attorney form going into effect. I believe it's June of this year, 2021. If you have a power of attorney that you signed prior to 2009, 2010, or prior to this new one going into effect, as long as you use the appropriate form for, at the time it was done, there's no issue with your power of attorney. So for example, though, in 2012, if I used an old power of attorney form that didn't comply with the 2009, 2010 changes, that power of attorney form is not valid. But if at the time you signed it, it was the correct power of attorney, that form was valid. I do think people should check their powers of attorney, make sure they are up to date in terms of the gifting provisions and the statutory gifts rider. But again, if it's a valid power of attorney, it's a valid power of attorney. I think it is important for powers of attorney to allow for gifting. And the reason I bring up the gifting is, God forbid, there's a medical emergency and someone needs long-term care in a nursing home or care at home to be provided for by Medicaid. We would need the power of attorney to be able to transfer assets. So you want a very broad power of attorney to allow for the transfer of assets. Sally, was that the full question or did I miss a part of it?
I think that was it. There are a few more questions, which is really awesome. Thank you everyone for participating. I would like to get more information on the nonprofits who could be appointed for POA, HCP, etc.
Okay, so either the question is, if someone have more information on nonprofits who can act in the stead in terms of a healthcare proxy power of attorney, I will defer to the Yonkers NORC if you guys work with WJCS in terms of that aspect. If not, someone can send me, I'll facilitate with Sally, after this, and I will give her some names of some nonprofits who I believe would stand in that stead.
Okay. If I have a bank account and didn't put down a designee, who will receive both my checking and savings accounts?
So the question is, if there's an account in my name alone, so we'll just use me, upon my passing, what happens to it? So because there's no designation, it's part of my estate. So if I have a will, the monies in the account, checking, savings, money market, CD, will pass to the beneficiaries named under my will. If I don't have a will, it passes to my estate through that estate administration and to the distributees of my estate through that estate administration. Those funds don't get paid to the state, paid to the government. They get either part of your probate estate if there's a will, or the estate administration if there's no will.
Okay. Can someone named as a I think we already answered this. Can someone named as a beneficiary in a will also be named as the executor? I think we already answered that one.
We covered that and we said yes. Here, I have a question here, which is a good one, Sally, so I'll put you on hold for a second.
Sure.
Since I have long-term care insurance, do I need to protect my assets from Medicare if I need to go to a nursing home in the future? I think that's an excellent question. So two things. First, there's a difference between Medicare and Medicaid. Medicare is a health insurance program for people 65 or older, or for people who are disabled who've been receiving Social Security disability for 2 years. Medicare covers short-term care in a nursing home or short-term care at home for rehab or rehabilitation purposes, for speech therapy, occupational therapy, physical therapy, and the like. Medicare does not cover long-term, what's called non-custodial care in a nursing home or long-term care at home for when a person doesn't need that skilled care. When a person needs long-term care at home or long-term care in a nursing home, that's when long-term care insurance, private pay, or Medicaid would come into effect. With long-term care insurance, there are a couple of, and I don't sell long-term care insurance. I'm not an authorized long-term care insurance person. Most newer long-term care insurance policies have a basket of benefits and an amount that can be used towards care. So it might be $300,000, $400,000, depending on the policy. And that policy might have an inflation rider or not have an inflation rider in terms of the daily rate that the policy will pay for either home care or nursing home care. So it's important for us to see what the amount that will cover in total. For example, if it's a $300,000 policy, most nursing homes in the county now run between $16,000 and $18,000 a year. So that would be about $180,000, I'm sorry, a month, which would be about $180,000 a year. So your $300,000 policy would only last, if you're in a nursing home, for about 2+ years. So it's very important to see how much care the policy will cover. I do like long-term care insurance policies as well because they do cover assisted living. Many of them do, which I think is a great, for in between when someone doesn't need nursing home care, but someone doesn't want to be home anymore. So it really depends on the policy. A couple of years ago, also, the long-term care insurance premiums, the yearly premiums had skyrocketed. So we had a lot of clients coming in to do Medicaid planning, to do Medicaid, Medicaid Asset Protection Trust. And then after the 5 years, got rid of their long-term care policy because it was just getting too cost prohibitive. We have another here. I have an elderly uncle with Parkinson's who has asked me to help him set up a will. We're both nervous about in-person meetings with an attorney. Would using an online will creation service be a horrible idea to serve for now and perhaps create an actual will with a lawyer after COVID? I think that's an incredibly good question. And it's something I wanted to raise when we were talking about the power of attorney form. Yes, I am an elder law attorney. I've been doing this for a very long time, and I do elder law planning and elder law and estate planning. There are online programs to create wills, trusts, advance directives, and the like. I don't recommend them. First, they're not normally specific to a state. So I do know I've seen powers of attorney online done through, we'll call it, legal, web legal. I don't want to use, point out any of the providers. And they might have a power of attorney, but it might not be a New York specific power of attorney form. And it also might not be a New York specific will. I will say that our practice here and most of the elder law estate planning attorneys that are my colleagues, at other firms in Westchester, first of all, we're all using Zoom regularly to meet with clients. We've very much limited clients coming into the office and understand for our office's safety and individual safety to limit exposure. So until a will signing, we meet with the client, all on Zoom or conference call and do everything, via, either phone or internet medium. In terms of will signings, what our office is doing is I actually live not far from our office. We've been doing the will signings in my driveway. We were doing that from the spring into when it got cold and my husband and daughter said we don't want to be witnesses anymore. But we have an outdoor parking lot right by our office where we're doing signings. We're doing signings in my driveway with the bay doors open. What we also do with signings is we pre-tab every document, sign here, date here, notarize here, and whatnot. So the signings themselves go very, very quickly. And we review the documents before the signing. So when we get to the signing, hopefully there are no other questions. This is what our firm is doing. I know most of the other firms are doing that too, because the safety of all individuals, our clients, really run paramount. And you should really, if there's an attorney you wish to use or call me, you can go over anyone's practices in terms of, keeping individuals safe. But I don't recommend using, we'll call it web legal type documents, even in the short term. I think, most of our offices, my office, Dania, Scanlon, Sirignano, and others are very, have really gone through COVID procedures and have procedures in place to keep our staff and individuals safe as well. What else? Because as you guys can tell, I could talk about this topic for hours, but I know we just have a couple minutes left. I can just keep going and bring up other issues, or Sally or any of the individuals if you have other questions.
Yes, if you have questions, please put them in the chat, because this is very important. If you have property in another state, what are the benefits of putting it in a trust?
Excellent. I just saw that pop up here too. I think that's an excellent question. So we live in New York. We live in Westchester County. We have a house in Westchester County, and we also have a house up in the Berkshires in Massachusetts, or at the Jersey Shore. So what happens? The reason why it was probably recommended, or I would recommend having that property outside of New York in a trust, is this: upon passing, and your will is admitted to probate, it's admitted to probate in New York. Most states then, with real property, require you to do something called an ancillary probate, a second probate in that other state where the real property is located. So I bring the probate in New York. I have my letters testamentary of my probate in New York. And then I would have to file what's called an ancillary probate petition in that other state, in terms of then marshaling the real property that's in the other state. So if my house in the Berkshires or the Jersey Shore or whichever other state, or my condo in Florida, were titled to my revocable or irrevocable trust, we avoid that ancillary probate. And upon my passing, that property could be deeded to the beneficiaries in that trust, or the trustees of the trust would sell the property with the proceeds deposited into the account titled to the trust and then distributed to the trust beneficiaries. Oh, this
all
is
right. There was one question which I missed, and then we can go to the one that just came up. How long does it take to implement a trust, and how expensive is it to set up?
Okay, so as a practice for most attorneys, we don't discuss legal fees in this type of forum, because they can become very individualized depending on the work that needs to be done. In terms of the setting up a trust, I'll tell you what my office's process is, and probably most other elder law estate planning attorneys. We have a consultation, and Sally and I would meet either over the phone or over Zoom or Web Connect or another FaceTime or another mechanism. We'd go through what Sally's family is. Is she married? Does she have children? Does she have grandchildren? Anyone have any disabilities? We go through Sally's income and Sally's assets, and we discuss what Sally's goals are. Are they estate tax planning? Is that why we're doing estate planning? Are we doing estate planning because she hasn't done any before and wants to make sure she has a will and can leave, has kids she wants to protect or have a guardian for? And does she want to do Medicaid planning? We then come up with the plan. Sally's going to do a last will and testament, her advance directives, and an irrevocable trust for her house and possibly some of her assets. I would send Sally a retainer letter saying, Sally, these are the documents we've agreed to do. This is what the cost is. Once you pay us, we'll draft the documents. It usually takes us about 3 weeks to draft the documents, at which time I would mail or email them to Sally. She'd review them. She'd fill in any of the blanks that we might not have discussed or didn't give any information for. She'd say, hey, Sarah, I don't understand this. Let's have another call. I'll explain it. We'll finalize the documents, and then Sally will sign. So it could be a process that could be 3 or 4 weeks, but if Sally never gets back to me, it might be, 6 months to a year, but it normally takes, from soup to nuts, I'd say about eight weeks, within that realm. There was another question here.
Right, how much does it
cost? We're not going to discuss. Or will it be better to just have a will and hope that my children will be generous to my grandchildren, or should I leave a letter to express my wishes? If you're leaving let's say you have 3 children and you're leaving your estate to your 3 kids, it's up to them if they want to give your grandchildren any money. So some people like to do what's, a specific bequest in the will of, X amount of dollars to Sally, X to Barbara, X to Alexis, X to Chris, each of my grandkids. Or it's up to their children whether or not they want to then use some of those funds for the grandkids. And then does leaving physical items to someone, i.e. jewelry, need to be included in a will, or can a notarized document that lists who should get what be enough? Most attorneys I know, myself included, we try to have very few specific bequests of tangible personal property that have value listed in a will. They can be listed in a will. I leave to Sally, Grandma Jane's engagement ring. I leave to Alexis the armoire that's in the guest bedroom. I leave to Gloria, Grandma's silverware. That's fine. Or you can also leave that list and say, hey kids, like this is where we want everything going, or let the kids fight. And just, on a personal note, it's always interesting. And right, we take what we learn in our practice and try to apply it to our personal lives. So my mom passed away a bunch of years ago now. I did most of the cleaning up of the house with my dad when he was getting ready to sell it. And anytime I did anything or took anything at the house, an email went out to my siblings or like, I'm at the house with dad. This is what we've done. This is where things have gone. And then we had that big powwow is you pick something, I pick something, you pick something, I pick something. And we, everyone gets along, it works. And the grandkids said, well, I really like that. Or we'll put that in storage for those grandkids. So it really depends on a family dynamic. And if we're talking about our children, we know our children best, and don't try to hope that they get along if they don't. And again, then I would leave more direction than less. And that's really, again, a very personal choice.
Hi, everyone. This is Z from Yonkers Public Library. Thanks so much to Sally Pinto and Alexis and Barbara from Newark. Thank you to our community partners, WJCS, the City of Yonkers Office for the Aging, Westchester County Legislator Ruth Walter, Friends of Crestwood Library, and Yonkers Public Library for making this phenomenal partnership. And we thank each and every one of you for being part of our wellness community. Be well, stay well.